Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Sorry, give me a second. I put my glasses inside my robe there. Good morning. We are here today for oral argument in the case of Wright v. Wright, our case number 1 CACV 190519. Obviously, we're here for oral argument. Each side has 20 minutes. Counsel, if you want to reserve time as appellant for rebuttal, you're free to do so, but make sure you do it on your own because we don't keep track of that for you. We conferenced the case this morning. We have read the briefs and we're familiar with the record, so keep that in mind as you present your oral argument. These proceedings are being, I believe, live streamed on YouTube and will be recorded on YouTube, so you can come back and watch yourself later if you really feel the need for the experience. But because of that, please, when you start speaking, introduce yourself, tell us who you are and who you represent. I think that's it. Oh, Judge Cruz pointed out, I think that you can do something so that they can see the clocks.
So if you run opposite clocks, then it's easier for counsel to see without getting up.
Okay. That will help you a little bit with your time.
Clock will be Applebee's and yours will be the other.
Okay. And I believe that that's covered everything that I need to cover. You can stay seated at your table. The microphones there will pick you up because we've taken the one away from the podium. All right. With that, counsel for appellant, you may proceed.
Thank you, Your Honors. May it please the court, my name is Yvette Ansel, and I'm here representing the appellant, Paul Robert Wright. We all sit here 9 years after a 2011 decree dealing with wife's motion to set, wife's motion to divide assets under 25318. And in her motion at paragraph 24, she alleges that this court has jurisdiction over the petition to divide an undisclosed asset. The family court only has subject matter jurisdiction over the division under 25318 if two questions are answered. One, is the asset community property? Two, was that community property intentionally omitted? On the second appeal in this case,
and just counsel, just so that
sure.
we're sure, no one disputes that the asset was community property.
Correct, Your Honor. That has been decided. It's the second question that's unresolved, that's had to be resolved. And in that second appeal, the appellate court did mandate that the trial court must resolve that second question. But when it went back down to the trial court, there has been no finding nor any ruling, implicit or explicit, on the subject matter jurisdiction on the second question.
Hold on for a second.
Sure.
Because subject matter jurisdiction is controlled by statute, and the statute specifically gives the superior court the authority to rule on matters of concern that are raised within Title 25. So the court clearly had subject matter jurisdiction.
Well,
the question before the court is, did it have the authority to allocate a particular resource after the decree was entered under 318, right?
that is correct, Your Honor.
That had nothing to do with jurisdiction. It had to do with the authority.
Well, it's almost one and the same, Your Honor. Because,
no, it's not.
Well,
jurisdiction is saying, no, you can't. I can't even get to the merits of this. Where the authority is, yep, you've convinced me. It was there, and I'm not going to, or I'm going to because the authority is not jurisdiction.
Well,
authority is separate. But we don't need to discuss that. We can simply go to whether or not evidence was presented that would indicate this asset was either intentionally not included in the decree or was a community asset, which you've conceded it was, and it needed to be apportioned correctly.
Well, Your Honor, but I do dispute that this is a matter of jurisdiction, because if the asset was unintentionally omitted, then it is no longer within the purview of the family court. There can't be a decision under 2518.
Because he or she would not have the authority to allocate.
Correct.
So we're
So,
just talking about the authority of whether, once they look at the merits, they can say, nope, I don't have the authority to do anything with this.
well, and I'm still arguing that it is a subject matter jurisdiction question, because I don't think the family, if it's not within 25-318, if it was unintentionally omitted, and we might be saying the same thing. But in either case, there was no ruling, either implicit or explicit, that, and I'm going to use the word subject matter jurisdiction, that there was subject matter jurisdiction which answered that question. The
Why
court,
isn't it implicit?
how isn't it
Why,
implicit, Your
yeah,
Honor?
why isn't it an implicit finding? If the court took this asset and then reallocated it, doesn't that mean that it found that it had the authority or had jurisdiction to do it?
Well, the problem is the court skipped a step. And if I may even use your quote in the case of Ridley, which is even more appropriate in this
I believe
case,
I
given.
dissented in Ridley, didn't I?
You did, Your Honor.
So then I wouldn't quote my dissent. It has no
Well,
authority to me. So.
But in terms of your position in
Brilliant,
Ridley,
though.
in terms of your position in Ridley, and Ridley involved another matter where
Involved an affirmative defense that had not been
correct.
argued or found by the trial court.
Correct, Your Honor. And we're in a different place right now. We're in a place where we have a post-decree issue, 9 years down the line, where we're in a court that might not have the ability to hear the issue. The burden of proof is on the person bringing the
But that's the whole point
claim.
of the litigation here. This was all squarely presented, both in the prior case and what the remand was for, was to specifically decide this issue. The trial court then gets that remand, is given specific instructions, and then reaches a decision, and you're saying, well, they didn't decide it?
Well, because they put the burden of proof on husband to prove by clear and convincing evidence.
Isn't that what the remand required?
No, Your Honor. The remand had to do with the question of whether the disputed property was intentionally omitted to determine if division is appropriate under 25-318. So that question rests on who brought the claim. If wife clearly brought the claim and she asserted jurisdiction, she's the one with the burden of proof. There is nothing at all in the trial court's decision.
Oh, wait a minute, hold on. What would be her burden? Her burden would be, one, there was a community asset, and two, it was not allocated in the original decree. Isn't that her burden to show a claim under 318?
Correct, Your Honor. I
Okay,
agree with that.
And you conceded that, one, it was a community asset,
Correct.
and I'm assuming you're conceding that it was not listed in the decree. Now, not as it relates, well, the 529s you say were in the decree.
Correct. The 529s are another matter.
The loans were not in the decree.
Well, but Your Honor, now we're talking about semantics, because, and before you even.
Yes or no, were the loans listed in the decree?
Well, the loans weren't, but husband kept his bank accounts as his own, and the original monies were in those bank accounts.
I thought they were not in the bank accounts at the time of the decree.
I believe so, Your Honor, but the argument and we're getting into the facts now, which is something that husband is asserting we can't get to because the court didn't say.
So let me take up that very issue, and sorry for interrupting you, but if we, the Court of Appeals, sent the matter back to determine whether, what was the proper classification of the proceeds, whether it was sole or community property, and whether the parties chose to omit from the decree, why would we send it back to a court that has no jurisdiction to hear the issue?
Well, we don't know whether they have jurisdiction yet, Your Honor.
Well, we wouldn't send back to a court that has no jurisdiction, I'll tell you that.
Well, but that determination might not have been made by the Court of Appeals. The Court of Appeals sent it back down to determine if there was jurisdiction when it sent it back down to answer the question whether the disputed property was intentionally
Where
omitted.
in that, can you direct me to where in our decision it says that we sent it back to determine jurisdiction?
Well, the question was whether the disputed property was intentionally omitted to determine if division is appropriate under ARS 25318D. That was the directive of the court when it sent it back down. So the court's duty was at first to determine that it had jurisdiction to decide this issue. The burden should have been on wife.
No, it was sent back to determine whether division was appropriate. And if the court has no jurisdiction, subject matter jurisdiction, then it cannot determine whether it was appropriate or not.
But the Court of Appeals decision never said that. The Court of Appeals decision never said that the court had subject matter jurisdiction. It sent it back down. A husband's position is it sent it back down for that determination of subject matter jurisdiction to answer that question. And let me give you an example in a completely other area of law.
All right.
Let's say the state charges Mr. X with murder, and you start the trial, and the judge says, you know what? Because you brought the case, state, we're going to have Mr. X determine whether he's guilty or not guilty. Because that will encompass that you already made your case, you already determined what was going on. You're completely skipping that step.
But Ms. Ansel, that's ludicrous, because the state has the burden to prove that the court has jurisdiction, and they do that by putting on a police officer to say, this crime occurred in Maricopa County, blah, 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 blah. But once jurisdiction is established, they don't shift the burden. And in this case, the jurisdiction of the court is, I have a matter under Title 25. And you say, yep, you sure do. The parties were married in Arizona, or they're divorcing in Arizona, whatever the case may be. And you're raising a claim under Title 25. That gave the court subject matter jurisdiction to decide the issue. And then you go to the next step. Was there a claim, that an asset that was not included in the decree? And you said, yes, there was. Arguably, there was an asset included in the decree because the proceeds were community property. So then you say, were the loans or the 529 accounts, were they included in the decree? But we've already established jurisdiction. We're simply saying who has the burden of proof once the claim has been made. So this is not about subject matter jurisdiction. This is about the authority of the court to award the asset under 318.
Well, and accepting your position, Your Honor, the court still put the burden on the wrong party and put it in on a heightened standard. And if you look at this globally, you have the family court bar, which is going to misinterpret where the burden is. You just make a claim under 25318 years after a decree is final, and there is no finding that the party bringing the claim has met its burden, yet it shifts immediately to the other party. And you've got a majority of the cases that come up.
But isn't it undisputed that the proceeds were community property? There's no dispute about that.
Well, now, but I mean, wife has changed her position to.
But are you disputing, or did husband dispute below that those proceeds were community property?
And Your Honor, I'm sorry, I didn't do the court below, but I think his position was always the same. It was something that he purchased during the marriage, and wife knew about it. So that leads to, yes, it was community property.
So we have an asset that is, at that point, she's met her burden to establish it was community property.
Correct.
Okay.
We're only dealing
Now
with
we're
the
talking
second
about
part.
Whether it's been intentionally omitted. What is the theory under which husband would assert that it was intentionally omitted?
That there was an agreement between the parties prior to even going to their mediation,
Right.
and prior to entering the decree.
And isn't our law very clear that in order to establish that community property is now separate property, i.e. a gift in this case, that the burden is on the husband, or the party who's asserting it's separate property, to establish that by clear and convincing evidence.
All true, Your Honor.
All true.
But
And when we remanded this case, I wasn't on the panel, but when the prior panel remanded this case, it said, burden is on the husband. Husband had to present clear and convincing evidence refuting the presumption that it's community property.
That it's community property.
So what did the trial court do wrong then?
Well, because we were dealing with the second issue. What the
Yeah,
trial
the second
court...
issue is whether she gifted this undisputed community property to him to convert it to separate property, and that's why it was omitted.
No, Your Honor. The second question was whether it was intentionally or unintentionally omitted from the decree.
Right,
because,
but the only basis for it to be intentionally omitted would be if she had previously gifted it to him, converted it into separate property.
Well, but the gifting issue, I mean, you're dealing with the community property issue, which has already been decided. So that's not at issue. What the trial court did was it conflated the two issues rather than dealing with them separately. The community property...
I think that's what our remand told the trial court to do.
Ms. Ansel, I have a question. I really want to move beyond this because I want to get to the actual merits. Are you conceding that there was not clear and convincing evidence of a gift?
No, Your Honor, I'm not conceding that.
Well, then let's move on to that point.
Well, but Your Honor, I just don't think that the court can get to that point because...
You know, when a judge says, let's get on to that point,
Okay.
then perhaps the better course of valor here is to get to that point.
Okay. The issue of husband maintaining his position throughout the last 8 years about this asset has never changed. Wife has changed her position multiple times. In the first trial, she said it was an inheritance, it was his second property.
Because that's what he had told her.
Well, that's what she stated. Then you have Mr. Gruber, who was the party's life insurance or insurance person agent since 2002, saying she knew about it. She discussed it with her, with him and her husband, and all of a sudden it's community property. And she also made statements during the first trial where she said, well, had I known it was community property, I wouldn't have, agreed to let him have it. So she's changing her positions back and forth all over the place.
Okay, but let's get beyond what happened in the first volumes of litigation to the clean break after the last time it was before our court and the specific determination this court had to make. So let's get there.
In terms of what, Your Honor?
Well, wasn't there a factual determination as to whether or not it was a gift made by the court
In this last
round?
hearing, there was a determination by the court regarding that. Correct, Your Honor.
And the court believed wife over husband in that it was not a gift, that she never intended to gift the money.
Correct, Your Honor, but the court also didn't take into account all the various positions of wife going back and forth and taking completely diametrically opposed positions. So
Did he say that? Did Judge Driggs say that? Or is that just your interpretation that he failed to consider?
Well, Your Honor, those are the facts because that's what wife did. She always changed her position to fit her narrative.
That wasn't my question. I'm sorry, maybe I wasn't clear enough. When Judge Driggs ruled in this case, did he say, I am not going to consider the varying positions that wife has taken throughout the course of these proceedings?
No, Your Honor. But that might be the issue with the whole case. Husband's position is that the court is implying things into the decision that happened that aren't said outright. That's the problem. It's not clear. If this is the law of the land for going back on a 25-318 claim, certainly pro-pers who go up are not going to understand that it's their burden it's their burden of proof first before the other side has to come with clear and convincing evidence.
Why wasn't the asset listed?
Why wasn't the asset listed?
Uh-huh.
Because there was an agreement long before the parties went to mediation that the asset was going to be husband's.
What
And-
about the other property that was separate property but was listed? Why was that listed?
And, Your Honor, I don't know if I have a good answer to that. What I can tell you is that it was a pro-per consent decree. And a lot of times, when you have pro-pers writing consent decrees, they leave out things.
Well-
They don't do it completely.
But pro-pers are held to the same standard as an attorney, whether we agree with that or not. We don't have two sets of laws and rules for, people who are represented, people who are not. That's just the reality we're living in, unfortunately, in many cases.
Well, and that's true, and that might be the best argument for the lack of a clear finding by the trial court to say that wife has met her burden before they jumped to husband having to prove by clear and convincing evidence the opposite.
So your position is that wife did not meet her burden in showing which portion?
Well, Your Honor, we don't know because the trial court never said whether she met her burden or not, whether it was unintentionally omitted from the decree. So we could move forward to jump to the clear and convincing burden of proof on the other side. And quickly, because I just want to reserve a little time, in terms of the 529 accounts, as Judge McMurdy said, those are clearly listed in the decree. Husband gets to keep all his bank accounts. The 529 accounts were bank accounts of husbands, so those certainly shouldn't, that should be reversed because they clearly don't fall within the statute at all. And I'll reserve the rest of my time.
Thank you.
Thank you. Keith Berkshire, may it please the court, Keith Berkshire for the attorney for Applee, Jennifer Wright. I was looking this morning because I couldn't remember when I filed this thing, and it was July 26th of 2013. In Wright 2, this court resolved that it was community property and not in the decree, the end. They called it the proceeds. If husband thought that the 529 accounts didn't fall under that, they could have distinguished then. This court ruled on our claim that the proceeds, that was the life insurance proceeds, the entire $500,000, he could have PR'd this to the Supreme Court. If he didn't agree with it, he could have fought that then. The remand was on the proceeds. One of the things that counsel just said, that she wants the burden on us to prove first that they were unintentionally omitted from the decree. If you read 318, it says, is it community property? 318D, is it community property? There's two parts. Is it community property and is it in the decree? It doesn't say, is it unintentionally left out of the decree or intentionally left out? It just asks those two questions. This court in Wright 2 found it's community property not in the decree and remanded it saying, under Thomas, it is possible that it was purposely left out of the decree and put the burden on husband pursuant to gift, as you stated, Judge Morris, to state that if you left it out and awarded to the husband, the only standard you can apply is a gift. If they left it out and it was titled jointly, you don't have to prove a gift. It was the title controls it. But here, husband says, only look at that it was left out. Ignore the fact that it was with me. Actually, technically, the gift was or the proceeds at that point were being held by husband's girlfriend without loan documentation, his now wife. That was where the money was. It was not in husband's bank accounts. That was resolved in Wright 2 as well. They still apparently are making that claim today. It was in his girlfriend's bank account, his current wife, at the time. That's where it was. It was not listed in the decree. This court essentially, our position in Wright 2 was you don't get to even consider where it was left, whether it was intentionally left out or not. That 318D is two parts, which is community, not in the decree. Our position was that's where it ended. This court did not fully take our position. You stated, under Thomas, there is a third option, that if you did purposely leave it out and purposely give it to husband, and husband can prove that by clear and convincing evidence, the quote you cited, Judge Morris, that then it can go to him. The trial court here listened to all the testimony, listened to the evidence, looked at everything, and stated he didn't meet that burden. That's where it should end. Interestingly enough, one of the questions that Judge Cruz asked was about why was it not listed? I'd go back to one of our main cases in this was the mediation intake, which has been admitted in every one of the hearings we've had in this case. where he lists separate property. There's a question about, are there outstanding loans to either party? This is how the court described it. It was a receivable, and he puts no. So the court listened to all this evidence, listened to the parties, they questioned my client up and down, Mr. Pollitt did, about whether her prior disclosure statements and things filed back in 2012 were, an acquiescence that husband was gifted this asset. And after listening to all the evidence, all the testimony, everybody that testified, both parties looking at all the exhibits, they said husband didn't meet his burden to show it's a gift. Now, this is there is an interesting legal question out of this that Wright 2, if it would have been published, could have, resolved, which is this interplay between like what Thomas means. Okay, Thomas to me is like Toth or in remarriage of Fong. It's one of these cases that's really based on the facts of that case, which is unquestionably in Thomas, the parties left out the condo. Not only they leave out the condo, they signed a deed after the fact transferring the condo after the divorce was over. So in Thomas, they stated the court doesn't have any authority to deal with this based on those facts. This court in Riniger, 4 years after Thomas, went through and said, Thomas is Thomas. That facts are Thomas, very Thomas specific. And specifically in Riniger, this court found that there was no distinction of where you brought the case. There was no, they went back to the Marvin Johnson, there's one superior court and you can bring it anywhere you want. And specifically, one of the quotes out of Riniger in paragraph 12 was, there's no jurisdictional impediment to a family court rather than a civil court considering these questions. The difference between a 60C claim, 85B now, and, a 318D claim. So this issue has been, resolved, and I believe that this court has, in Riniger, narrowed what Thomas states. I think this court could actually do family court practitioners a favor, as actually alluded to by Ms. Ansel, about what happens when parties do leave this stuff out. What happens when it's disputed? What is the burden here? Is the gift standard the correct burden to apply when somebody alleges something was left out on purpose? That case happens a lot. I have two other ones right now at the trial court that are allegations that a decree that parties purposefully left something out where one of the parties is contesting it. So it's not Thomas, it's more of this case of what is that standard. And this is, one of the things here that I think is important to look at is husband never really took a position at the trial court. If you read the pretrial statement, husband never took a position on what the standard should be. We're the only ones that did. And actually, if you read the beginning of the transcript in this hearing, I was trial counsel on this one, asked if they would take a position and say what they believed the standard should be, and they didn't. They only argued two things at the trial court, which was a mistake, that wife was simply arguing a mistake of law.
I always find your discourse interesting, but I'd like to focus a little bit more on this case, and specifically in this case. At the time the decree was entered, the proceeds, it wasn't a lump sum of money. The proceeds had moved on. And we had 529s, two of them, and we had loans. And so the issue then is what was included in the decree. Now let's start with the 529s. The 529s existed at the time of the dissolution, correct?
I believe so, Judge, yes.
And the decree said that bank accounts in husband's name remained his sole and separate property, correct?
Correct.
So since the 529s were in husband's name at the time of dissolution, at least to the extent of the 529s, any proceeds from the life insurance had been allocated in the decree, right?
This was the issue of Wright 2, Judge. This was, I understand your position, and this is a position that husband has taken, including up on the second appeal here, was that, and one of his summary judgments was that is in husband's name. This was dealt with, I believe, in Wright 2 by the fact that it was just solely...
Or maybe we were just inartful in Wright 2, and we were talking about proceeds generically without specifically drilling down into the nature of the claim.
And I think there was
But,
actually
you know,
a
we can be
distinction.
wrong. We can be wrong, and I'm asking you specifically. If the 529s were in husband's name, and so it's a bank account in husband's name, and the decree allocated those bank accounts, then it would be error under 318 to reallocate those bank accounts, correct?
If specifically they were found to be under that provision, I think it would be, to reallocate something that was already allocated. However, once again, this was an issue for Wright 2. This was specifically an issue dealt with in Wright 2, and why in Wright 2, this court does actually distinguish between the two of them and still classifies it as all of the proceeds. There is a distinguishment in towards the end of the case that then brings it back to one issue. The court also then goes to the trial court. I mean, again, this is also one of the arguments that husband made in the eventual hearing on this, was that they were in his name as well, that the court found no, that 318D didn't cover this. These were accounts that were for the benefit of the children. They were, although he's the trustee, that didn't deal with it, the waiver or whatever you want to call it, the provision in the decree. So not only did the trial court deal with this, but I believe, again, Wright 2 directly did this, and if they had an issue with that, they could have taken that up as well if this court did it incorrectly. But the proceeds term was defined as all of it at that point. It was all of the life insurance proceeds. It's the same as their claim in the end here, that there's no proof that the $150,000 is the right amount. They disputed bank accounts. They only did that in the appeal. They never did that in the court, saying here's the exact amounts of what the loans were to his girlfriend and these things at the time. So I understand the question, Your Honor, but it was, again, I think this was fully, I mean, he didn't PR it. He didn't do anything. The proceeds was a defined term used by everyone in Wright 2. I mean, unquestionably, the loan proceeds or receivable from his girlfriend, boss, whoever had the money at that point, and I can't remember which one had it. It was, he loaned the money to his girlfriend to loan to his boss to buy the company he worked for, or something to that effect. That was definitely not in there. But again, one of the other things in this is nowhere in the mediation agreement were any of those listed, the 529s for the children or anything else. The court listened to all this evidence. They listened to, and basically didn't, you know, my client testified that husband told her all this stuff was gone. He had to pay back all these loans to his friends that he had been living on, that he was, during his current job, he was sleeping in his car with bullets whizzing around him in California because he had no money and had to borrow it to live on. So I guess I get back to the question, the original issue, which was, you know, this court could use this opportunity to clarify how do you get to a Thomas case of what is the burden on this? And I think what Judge Moore stated is probably the correct burden, that's the one I alleged, so, which is you'd have to prove not only that they left it out, but intended to gift it to get to a Thomas situation. Because the statute's clear. Is it community? Is it in the decree? Is it not in the decree? There's no intentional, unintentional. It's just those two things. Then it's held as tenants in common, subject to equal division, is what 318D covers. The jurisdictional, I don't know if the court wants me to get into some of the jurisdictional questions on this. I think that the jurisdiction is rather apparent from the standpoint of once you make a claim under 318D and about these assets, that's what gives the statute is what, you're making a claim under the specific statute, which is what gives the court jurisdiction over the issue itself. And specifically, again, since in Wright 2, this court found that it was community, it was undisputed that it was community, and that it was not allocated in the decree. Husband argues a collateral estoppel argument. That was Wright 1, which they argued the claim preclusion and issue preclusion. That was Wright 1 that trial court granted and then was overturned by this court, finding there was no claim or issue preclusion, which then sent it back to be litigated for Wright 2. At the end of the day, and I'll let the rest of my time go here, at the end of the day, this was a factual issue for the trial court to determine whether the burden was met by husband, that the parties intended to leave these assets out of the decree and award them to husband. I think that's the part that appellant wants to ignore, is that whether they intentionally or unintentionally left them out of the decree, that's where they want you to end the examination. They don't want to get to the second part, which is, oh, and by the way, I get them as well. That's the part here that is the issue, is that it's not only just leaving out a piece of real estate that is jointly titled. If you left out a jointly titled house, that doesn't also allocate the house to gift community assets to somebody else. Here it is leaving out the asset and awarding it to husband. They don't want the court to examine that part when they're arguing about the burden of proof. That is the important part here, is it is leaving it out and giving $500,000 to husband, which, if you look at their decree, is larger than the equity in their house and the party's single largest asset.
Counsel, let's get back to the 529 accounts, because you said that in Wright 2, we, the Court of Appeals, treated all of the proceeds in sort of a lump category, and we didn't distinguish. And so therefore we sent it back so that the parties could give evidence as to whether they intentionally chose to omit from the decree, right? But when I look at Wright 2, at paragraph 14, and it's dealing with wife's cross motion, it says, but even assuming the decree did not allocate the policy proceeds, there remains a question of fact regarding whether the parties intentionally chose to omit them from the decree. It says, assuming that the decree did not allocate the policy proceeds. Couldn't that be read to mean, part of those policy, aren't they there talking about, let me go back and rephrase that last portion. Couldn't we understand that to mean that portion of the policy proceeds had been allocated? I mean, it does not decide that it's all one lump sum. It says if we assume that the policy proceeds were not allocated, it could very well be understood to mean that part of those proceeds were.
I guess I'm reading, overall in Wright 2, the court utilized the term proceeds exclusively as a combination of both. Except, and I'd also point out that they never raised a distinction at the trial court here, okay? They raised two issues at the trial court, which was what I was talking about earlier, which was collateral estoppel, which was Wright 1, and a mistake of law about the allocation. They never raised this issue. There's multiple issues that are in their appeal only that are waived.
But if in our analysis we run into the fact that a portion of that has already been allocated, what do we do with that?
Well, again, it's an argument that they never distinguished between it, and that it's a waived issue, because they never claimed this at the trial court to allow a distinction between the two on these issues. They never claimed here at this hearing after remand that there was a distinction between the two as far as the court's ability to award this. This is a waived issue that's raised for the first time on appeal in their brief, the same as the collateral estoppel, the same as the sufficiency of findings. These issues were not raised at the trial court level for the court to look at the testimony about these things, because read the pretrial statement here. It isn't an issue. They never distinguished between
Right, I understand that. But if it's already been allocated, whether they raised it or not, wouldn't we be committing error by reaching into an asset that's already been allocated to one of the parties and taking it out, even if they didn't argue it? Would we commit error doing that?
No, because if anything, it's an affirmative defense that they would have to essentially raise to say this has already been done. They didn't.
I thought 318 is the only mechanism we can reallocate it. We can reallocate it once a decree has become final, and this decree was final a long time ago.
It was. But again, when we are making the claim of the entirety of the proceeds, what you're saying is that their claim is now a portion of those loan proceeds. All the testimonies about the entire loan proceeds. They didn't distinguish between which is one of their claims on appeal. They're trying to distinguish out, well, the 500 wasn't right. It was really a little less than that because the loans were really, 390 or something. That's an issue they only raised on appeal that they didn't present below. The same as this. We didn't distinguish. We made a claim on the entirety of the loan proceeds not being covered. The court heard issues on the entirety of the loan proceeds, not a distinguishment between these two issues of that the 529s are somehow not part of our claim. Okay, that was what, they didn't make that claim at the trial court in anything to allow the court to hear that, essentially. I mean, this is really the definition of a waived claim, in our opinion. I mean, the pretrial is very clear on this. They only go into those areas, those defenses against our claim for the $500,000. That was all they did. And read in conjunction with Wright 2, I'm not sure how we get there. That was the motions for summary judgment and things like that. I mean, plus, realize that in their summary judgment motions,
They aren't, for the first time, raising the issue on appeal that these 529s contained proceeds. I mean, that's something that's been in the record for quite some time.
It is, but again, then the appropriate time, if that's the thing, that the court is going to look at this and say, hey, account's in husband's name, 529's in his name, so forth. That was what their summary judgment was about, essentially. You know, that could have been part of the summary judgment that they lost on that issue. I mean, they lost these issues. They didn't bring them again for when we relitigated this. That was, if what the court's saying is that we can simply look at this and say, those accounts, that's the definition why you do summary judgment, which they lost on review here. I mean, this has been an issue. They simply didn't raise it when we did the final trial on this, and the pretrial, the final one after 7 years. This was not a claim they made to distinguish between these items. And frankly, if that was the case, they should have won it on summary judgment, if we don't need to get into evidence, which we did. I said I was going to give you 7 minutes back, and obviously it's not truthful.
Thank you, counsel. You have approximately 44 seconds left.
I'm going to talk really fast. Just two things. If the standard is now going to be that anybody can make the claim under 25-318, and then it goes to the trial court, and then all of a sudden the other party has to show by clear and convincing evidence that that's not what's going on here, there's going to be a multitude of litigation in the family courts regarding this issue. And
Or it'll
people will be
provide an
confused.
incentive for parties to make sure they list everything on their 318 statements.
Could be, Your Honor,
Like
but
like
it's...
the other separate property that was listed in this case.
I agreed, Your Honor, but these are propers. And the last thing I'll say is that opposing counsel said that, made an issue regarding wife's changing positions, but as Judge Cruz pointed out, although she was a proper, she's held up to the standard of an attorney, she could easily have looked into any of these accounts and saw what was going on. She didn't.
Thank you both, counsel. We appreciate your argument today. We will take this matter under advisement and issue a decision in due course.